CBA President Amy Lynn Meyerson will now introduce this morning's opening plenary speakers.
Good morning. Welcome to the second day of the Connecticut Legal Conference. This morning's first plenary speaker is Chief Judge Stephen R. Underhill. Judge Underhill was appointed to the United States District Court for the District of Connecticut in 1999 and has served as the Chief Judge since 2018. Prior to his appointment to the bench, Judge Underhill was a partner at Day, Berry & Howard LLP, now known as Day Pitney LLP, where he handled a wide variety of commercial litigation, concentrating in insurance coverage, intellectual property, and appellate practice. Judge Underhill has long been active in the CBA's federal practice section. Welcome, Chief Judge Underhill.
Greetings. My name is Stephen Underhill, and it's my pleasure to present to you a report on the status of the federal courts in the time of COVID. Before I begin, let me just say that I hope you and yours are safe and well. We have all lost family and friends to this terrible disease, and it has been difficult to mourn them because of the restrictions on gatherings. If you're in that situation, my heart goes out to you. In March, when COVID hit, it had a dramatic impact on the federal courts. We have seen this in any number of ways. Courthouses have been restricted, cases have been handled differently, and we are all trying to make progress and move forward with a fundamental goal, and that is to protect public safety while operating courts. The impact of COVID on the federal courts can be seen in several ways. First, we've had a drop in civil filings. We currently have about 2,100 cases pending, and the cases filed this calendar year are down about 200 from prior year averages. So there's definitely been an impact in terms of the new cases that have been brought. We've also had a slowdown of grand juries. For some period of time, grand juries were unable to meet. They are now meeting in Hartford and New Haven, but there is still, as a result of the interruption, there have been fewer indictments brought by our grand juries. The biggest impact has been that there have been no jury trials since March of this year. There is a significant backlog of trial-ready cases on both the civil and the criminal side. For example, we have about 300 criminal defendants who, in theory, are trial-ready. The second biggest impact on the court's business has been the burden of dealing with motions for compassionate release from prison. The First Step Act, which was passed a couple of years ago, allowed federal prisoners for the first time to seek compassionate release from the district court. Prior to the First Step Act, only the Bureau of Prisons could grant a request for compassionate release, and those were very rarely granted, typically in the case of a terminal illness where someone was released to allow them to go home to pass away with their family. COVID, however, has provided strong arguments that many more people should be subject to compassionate release. Specifically those who are vulnerable to this disease, either because they have diabetes, they are obese, they have asthma, or other conditions identified by the CDC as increasing the risk of contracting COVID and the severity of the disease if contracted. So many of these motions have been filed with the district court. I don't think I saw a single motion for compassionate release filed before March, but in the period March through the end of July, 321 motions for compassionate release have been filed in our district. Of those, to date, 88 have been granted. This has been a real burden on the judge's workload. These are emergency motions that are often life and death. They are often heavily documented with medical records. They are ones that are sometimes strongly opposed by the U.S. Attorney's Office. And so these motions require a great deal of time and often immediate attention from our judges. There has been a similar increase in habeas filings during this calendar year. Last year, to this point in time, we had 29 habeas petitions filed, and this year we've had 52. Many of those habeas petitions also raise compassionate release type arguments. So that is directly attributable to COVID in my view. COVID obviously has also resulted in reductions in the access to our court buildings. The restrictions have varied over time, but currently you are denied access in essence if you have a fever of 100.4 or greater, or if you have serious complications or symptoms of the disease. And everyone who enters the federal courts are required to wear face masks at all times. Most chambers and court staff, clerk's office staff, are working remotely. They are able to do their work fairly efficiently remotely because of the CMECF electronic filing system. But they are not here to answer your phone calls like they used to be necessarily. They are not here to meet with you as they might have been in the past. If you leave a message with Chambers, I'm sure someone will access that message and will return that call. So I apologize for the inconvenience, but that is simply the reality that we are dealing with at the moment. Despite these restrictions and limitations, we are moving court business relatively well. Under what is known as the CARES Act authority granted by Congress, we are able to hold many proceedings that otherwise would have been required to be held in person by either phone or video conferencing. We're using the Zoom platform for those conferences, and it has been quite effective. An example of this would be a guilty plea proceeding in federal court. By rule, needs to be in person, but because the CARES Act granted authority, if the judge makes the appropriate findings, then it can be done remotely, and they have been done remotely quite often. The district court has been using Zoom extensively for all types of proceedings. Most of our courtrooms are video conference capable, so they can be used with the judge in the courtroom and others on Zoom, or at least some others on Zoom. So we have really three options at the moment. Some of our judges are conducting in-person proceedings with everyone spread out. Sentencings, arguments, these types of proceedings are going forward in person in certain situations. Often, instead of in person, they are done by Zoom entirely, everyone being remote and participating that way. And then we often now are doing what we call hybrid proceedings with some, but not all of the participants in the proceeding in the court and the remainder on Zoom. So with those three types of proceedings, we are able to move a fair amount of business, notwithstanding COVID. There are some slowness problems as we use Zoom, either in whole or in part. Sometimes someone will freeze. We have to go back and redo something. There are problems with translators, which takes a great deal of time over Zoom. But these are limitations that slow us down but don't stop us from conducting our business. And certain types of our business have been continuing almost unabated. A good example would be settlement conferences with magistrate judges. These are now very effectively done over Zoom. The magistrate judge can talk privately with one side or the other, or each side can confer privately in what's called a breakout room. And this has been a very effective tool to continue settlement conferences during the pandemic. There's been almost no drop-off from the March to July period. In 2019, we held 582 magistrate judge settlement conferences, and over that same period in 2020, we've held 549. So if you want a settlement conference, please contact the court, get assigned to a magistrate judge, and it can be done very, very effectively. The biggest impact, of course, on our business has been the jury selections and trials. These are activities that are extremely hard to conduct remotely. We are going to start returning to holding civil jury selections and trials starting September the 1st. We're going to do this carefully. It'll be something of an experiment as we try to find safe ways to effectively conduct jury selections and trials. How do you bring in 100 people for a jury selection safely? This is going to be something that's going to require some pre-screening, I believe, either through a questionnaire or through a Zoom proceeding. It may be that we spread out our jury selections. In federal court, we typically do them in a day, but we may be much closer to the state court model where it takes several days to pick a jury because smaller groups are coming in to be questioned. Once you get to trial, how do you have witnesses testify? Do they wear a mask? If so, how does the jury judge their credibility? Do you use plexiglass and allow the witness to take the mask off? If so, what kind of cleaning do you do of that plexiglass? Do you put the witness in the jury box and the jury spread around the gallery in order to have social distancing? If you do that, where does the public sit? Perhaps they go to an adjacent courtroom and watch on video. Perhaps they watch over Zoom. These are all questions that need to be sorted out. We need to find good answers to, and your help in proposing solutions to these problems will be greatly appreciated. On the criminal side, we're not going to start any criminal jury selections or trials before November 2nd. Obviously, criminal juries are larger than civil juries, and there are going to be more difficult problems that we face in those types of cases. Once we start moving those, we are going to have a lot of backlog to work through, and our priorities essentially are going to be which defendants have short trials and have been in detention the longest. Unfortunately, some of our defendants have been in detention in excess of a year or waiting a trial. Those folks need to get their trials sooner rather than later. So please understand if your client is not at the top of that list. We're also exploring, and I urge you to explore, the possibility of bench trials in criminal matters. Obviously, they're available in civil matters too, but they are rarely consented to in a criminal context. But I believe both sides are exploring this possibility. I do want to thank the Defense Counsel, the Defense Bar, for being so cooperative during this frustrating wait for trials. Obviously, the pandemic gives rise to an exemption under the Speedy Trial Act, but I'm sure that your clients are pressing you for trial, and I'm sure many of you would like to get your trials conducted. And it's been kind of gratifying to me that we have not had a lot of litigation over the speedy trial rights. So thank you for that. So what is to come? I think in sum, the district court intends to make a slow, patient progress toward a return to normal. I'm not sure how long it's going to take. We're going to go carefully so that we don't contribute to the difficulties caused by this pandemic. We are taking our cues from the governor as well as from health experts, and we appreciate any suggestions that you have about how to do things better. I will say I think remote proceedings are here to stay to a certain extent. Perhaps not on the criminal side, but on the civil side, I think the convenience factor is going to make them popular. Judges and lawyers seem to have developed a comfort level with the Zoom software, and I expect that will continue. On a personal note, I will say that I greatly miss the opportunity to gather with the bar, either at semi-formal activities such as bar association dinners, but also informally in the hallways of the courthouse. For 20 years, it was my practice to come down from the bench and shake hands with counsel after every court proceeding. Shaking hands has obviously been a victim of the pandemic. I do hope that the day will come, though, when you'll be back in court, I'll come down from the bench, and I'll be able to shake your hand. Until then, take good care, stay safe. Thank you.
Thank you, Judge Underhill. It is now my pleasure to introduce our second plenary speaker, my friend, Attorney General William Tong. He's the 25th Attorney General to serve Connecticut and the first Asian Pacific American elected at the statewide level in Connecticut. Prior to his election in 2018, General Tong served 12 years in the Connecticut's General Assembly, representing the 147th District, and served as House Chairman of the Judiciary Committee. General Tong has more than 15 years' experience as a litigator, and most recently served as counsel at Finn Dixon and Hurling LLP. Please welcome Attorney General Tong.
Hi, it's Attorney General William Tong coming to you from my office. I hope it's not too messy. It's kind of lonely here because we're still in the middle of a global pandemic. So most people are still out teleworking, but I'm here in the office, a lot of work to do. And I just want to thank you all for inviting me to spend a couple minutes with all of you in the Connecticut Bar Association and to congratulate you on your 2020 legal conference and pulling it all together in the middle of this unprecedented public health emergency. Before I get started, I just want to give a shout out to my very, very good friend and your fearless leader, CBA President Amy Lynn Meyerson, who is totally overcommitted to bar associations. So I'm not surprised that she's your president. You may not know this, but Amy is also one of the founders of the Connecticut Asian Pacific American Bar Association, and she was its president, and the National Asian Pacific American Bar Association, and she was president of that national organization. So Amy is totally and completely nuts about bar associations, and so we're all very lucky this year as a community of lawyers that Amy is our leader and is dedicating her volunteer time to the Connecticut Bar Association and leading all of us. Let me just say a couple of words about the work we have ahead of us in 2020 and beyond. I hope that all of you and that the bar community broadly takes this opportunity this year to show real leadership on a number of important fronts. And the first one is one that all of us are confronting together right now. You know, apart from the public health emergency presented by the virus, we have the long-standing public health emergency of systemic racism and institutional bias, and all the work we have to do in equity, diversity, and inclusion. And I want to thank all of you, from the sole practitioners who are watching to the leaders of big firms and the judges and the prosecutors and public defenders and everyone who's part of, and of course my assistant attorneys general across the AG's office, and everyone who is part of our broader legal community. I want to thank all of you for all of your work on equity and diversity and inclusion and further developing the law in our workplaces and our communities into places where we respect one another, we honor each other, and we treat each other fairly and equally, and with justice and respect. This is something that we are uniquely trained to do as lawyers. And I think that's really important. That's why I'm encouraging you to show leadership, because it's our job from when we enter law school and probably before that, but when we start our training all the way through law school, in our bar preparation, and then in the practice of law, we as a profession are dedicated and committed to and duty bound to examine difficult issues of racial justice, of systemic and institutional bias, of why what happened to George Floyd, why it happened, why he lost his life, why it shouldn't happen again, how it's happened to many other people before him, how as a country we continue to live with the original sin of slavery, and how we've worked to overcome that throughout our history and in the development of the law, from the civil rights movement of the 60s, and before that the Civil War, of course, and then the civil rights movement, and the development of the 14th Amendment, due process, equal protection that we see throughout our law now, in the Voting Rights Act, for example, and how we've overcome all of these obstacles through Brown versus Board of Education and Loving v. Virginia, and overcoming the legacy and history of Japanese internment. Lawyers did this work, and that's why we have to continue to do this work. We speak the language of, as I said, equal protection, due process, civil rights, rational basis, intermediate scrutiny, strict scrutiny, Caroline footnote, all of these things. Remember all those things from law school? And if you practice in those areas now, this is the language that we speak. And not everybody's equipped to have these conversations. So it's incumbent upon all of you as a community of attorneys to go out there with your friends, family, community, neighbors, cities, towns, clients, colleagues, firms, have these conversations and discussions and develop the law further, and develop a legal system, our legal system, so that it fully honors and respects everybody and their individual rights and liberties, so that we can be sure that the same is true for our society and our community and our country broadly. Let me also say that it's really important that all of you show leadership in talking about and drawing attention to and working through the difficult legal issues that we face as a country. Everything from making sure that we all have the opportunity to exercise our right to vote, and that we protect the franchise of all people as we head into this very, very important election coming up in November, to making sure that people understand what's at stake and what it means to honor the rule of law, and to honor and respect and follow what judges do and what courts do, and how important it is to honor the delicate balance between the three branches of government, and why it's so important to avoid constitutional crises. These are the words, the concepts that far too often now get thrown around at night on the evening news or on cable news. But they're getting thrown around and talked about because they're at risk, they're at issue. And lawyers are the ones who have to lead that discussion, that have to step up and say, we're going to do everything we can to protect our constitutional system. We're going to do everything we can to protect the right to vote. And we're going to do everything we can to ensure that the rule of law continues to dominate and guide all of us as a people. And, I don't have to tell you how important that is this year. It's very difficult. These are chaotic and confusing times. But I think if we all come together and do our work, I have every confidence we'll get through it. So thank you again for all that you do. And I hope we get a chance to get together in person sometime soon. Thanks so much.
Thank you, Attorney General Tong.
I'd like to thank our opening plenary sponsors, Cronholm Insurance Services and Liberty Bank. Cronholm is a CBA-endorsed provider of professional liability, auto, homeowner, umbrella insurance, probate bonds, committee liability, office packages, and workers' compensation, disability income plan, and employment practices liability products. Do not miss the CLC session, Safe Harbors and Calm Seas, on Tuesday and Wednesday at 2 p.m. to earn up to 7.5% premium credit off 2 years on professional liability insurance offered through this CBA exclusively endorsed program underwritten by CNA. Established in 1825, Liberty Bank is Connecticut's oldest and largest mutual bank with over $6 billion in assets and 60 banking offices in Connecticut. As a full-service financial institution, Liberty offers consumer and commercial banking, cash management, home mortgages, insurance, and investment services. Named top workplace by the Hartford Courant, Liberty maintains a long-standing commitment to superior personal service and unparalleled community involvement.